All right, let's call the meeting to order. Welcome, everybody. The first bill for our consideration is Senate File 171, City and Town Regulatory Reduction. Senator Nethercott's here. We'll turn the floor over to her. We don't do roll call.
All right, no roll
We
call.
can count to 5.
All right. Do you want to count off? All right. Good morning, Mr. Chairman, members of the Corporations Committee. You have before you Senate File 171, City and Town Regulatory Reduction. I think this is a good little bill without any objection from anyone involved. The purpose of the bill is to eliminate the duplication of the need for a survey when the circumstances concern when a parcel of land is being annexed into the city. The way the statutes currently work in conjunction with each other is the requirement for two surveys to take place in that circumstance. And so this issue was brought to me by my city, by the city planner, and with the full support of engineers and surveyors, recognizing that this is an unnecessary duplication of 2 surveys concerning the same platted parcels of land, and wanting to be efficient and to reduce regulatory burden on landowners and developers, to eliminate this unnecessary burden. So the duplication in the statute references, which I had intended to bring a copy for you, but I left it on my desk upstairs, is 3412-102, which is the other statutory section that requires the survey. Then in 2007, we decided to amend 15-1-413, which is the statute being amended through this bill draft today, which also requires a survey to be conducted. So if we look at the bill on page 1, you can see that we're striking the language and upon the change in boundaries of any city or town pursuant to the annexation under this chapter. So under 34, for annexation, Title 34 under annexation, there's already a survey required. Having a duplicate requirement of the survey under Title 15 serves no purpose. So with that, that's the bill. And Mr. Chairman, I know there's folks from the city who live and work in this space. I would be happy to speak and explain it to you more thoroughly. In the event you have questions, I would defer to them.
Thank you very much, Senator. Any questions for Senator Nethercott? Senator Landon.
Thank you. Senator, what was that other survey that you referenced? What requires that survey? I'm just curious.
Annexation.
So, Senator Nethercott.
It's annexation as well. Okay, thank
And
you.
statute reference again?
Wyoming statute 3412-102.
3412. Okay, yeah, there you go. All right, any other questions for Senator Nethercott? Who else would like to testify on this bill? Thank you, Senator Nethercott. Come forward, sir. You might want to stay close if you want. Welcome, sir.
Good morning, Chairman. Charles Bloom, Planning and Development Director for the city. First of all, I'd like to thank Senator Nethercott for taking this up. This is great. This actually came out of a conversation that I had with several engineers and surveyors. Back in 2007, the changes were made that require survey and monumentation for an annexation. So the crux of this is regarding monumentation, which is where you put the corners, on the ground, in the ground, so it defines where the property is, where the survey is. Whenever someone does subdivide, and in 3412-102, it does require that monumentation. So in the case of an annexation, what you have happening is a surveyor comes together, puts together a legal description, puts their stamp on it, that won't change. They accurately describe that survey, and then when it's complete, they're required to put these monuments in place. So whenever anyone is annexing and developing in a town, the next step in development after annexation usually is grading. You're going to change the grades so your drainage works, your slopes work, all of that work. So what happens if you just monumented it? Essentially, those monuments are taken out, so you're duplicating efforts. So what will happen is they can do the grading. Everyone knows where their property line is because it's development. They're aware of where their property line is. They're not intending to build structures or houses or infrastructure on other people's properties. And when they come in with their subdivision, they will do the final declaration of the boundaries and put those monuments in. So this is important in a variety of different Wyoming cities. Here in Cheyenne, we do annexations on the perimeter. Usually those are petitioned by landowners. Those are fairly large and they're developed in phases. And they're usually multiple tracts of land that might be under different ownerships. In talking with my fellow professionals up in Casper, they take a little bit more of a conservative approach to annexations, and what they do is they annex by ownership adjacent to the city. So for example, if you have a large development that is comprised of 4 different parcels that all don't touch the city at that time, they basically do a domino effect and they annex one, and that takes about 4 months. Then they come in and annex the second one, take another 4 months, third one, another 4 months. So you're looking at a pretty significant time for annexation. Under the legislation that's in place right now, they would have to do a survey every 4 months, when in the end, they'll have to do one final one when everything is done. So this really is just to make sure we're not duplicating efforts. We are saving developers a little bit of money, because these can run between 7,000 and 15,000. There are a lot of, it's really hard to put a price on it because it really depends on the scale of it. So that is the intent of it. I do want to note that this in no way changes the way the city does city-initiated annexations. This has no changes on any annexation of county islands within the city. Those are not a change in boundaries, those are an enclosure. So right now, the way the statute is written, it is not required for county pockets or county islands. There'll be no change to that process whatsoever. I'm open for any questions you all may have.
Thank you very much, Mr. Bloom. Any questions for Mr. Bloom? Looks like we're good. Thank you. Who else would like to testify on the bill? Thank you, sir. Yes, sir. Welcome.
Good morning, Mr. Chairman.
Good morning.
Bob McLaurin with WAM. We like the bill, support the bill, and appreciate Senator bringing it. So thank you very much.
Pretty in-depth testimony. Any questions for Mr. McLaren? Thank you, sir. Appreciate it very much. Anybody else like to testify on the bill from the audience? Is there anybody online? Committee, you've heard the testimony. What is your pleasure? Motion by Landon. Is there discussion? Any discussion? Sounds like a pretty good bill. Call the roll.
This is a roll call vote for Senate File 171, City and Town Regulatory Reduction. Senator Boner. Aye. Senator Dockstetter.
He's excused.
I think he left a vote.
He didn't hear the testimony, so we'll just excuse him.
Okay.
It's all right. He'll catch up fast and it's easy. It's an easy bill. He did leave a vote, but he did not hear the testimony, so we're not going to enter the vote. He's excused. It's perfectly fine. He'll catch up in no time. It'll be fine. He's excused.
Senator Landon.
Aye.
Senator Steinmetz.
Aye.
Chairman Case.
Aye.
4 ayes and 1 excused.
Perfect. Thank you very much. I take it you'll carry the bill on the floor. Thank you. The next bill for our consideration is Senate File 171, City and Town Regulatory Reduction. Who's going to lead us in this bill?
We just did 171.
Oh, sorry.
165.
I'm Senate File 165, cancellation of registration notice requirements.
Mr. Chairman, I'm on the bill if you want me to. It looks pretty simple.
Senator Steinmetz, go right ahead.
Would you like me to go to the chair?
It's total up to you. I just did that for the net metering bill because it was so inflammatory. I didn't want to sit up here. Go ahead, Senator Steinmetz.
Thank you, Mr. Chairman. This good little bill, I believe is brought by Senator Pearson, and I signed on to it, so it must be a good little bill. And
Yeah, that's it.
That'll tell you.
so in addition to mailing the notice, the county clerk may also provide notice to the elector by email. So we're just changing that small little addition, and I see Miss Langford out there. She might have some more testimony as to why they feel this is a necessary change from the Clerks Association. And so, Mr. Chairman, that looks like the impetus of this bill.
Thank you, Senator.
Thank you, Mr. Chairman.
Ms. Langford, did you want to address this bill? We're on Senate File 165. Go ahead.
Good morning, Mr. Chairman and members of the committee. I'm Mary Langford, and I have the honor of representing the county clerks of Wyoming. This is a good little bill. This is a cleanup, and you're familiar with the clerks bringing cleanup things to you that we run into through the statute as the clerks are doing their work. And as Senator Steinmetz explained, this would allow them to be able to email cancellations as well as mail. It's not a replacement, it's an addition. And I'm ready to stand for questions if you have any. And cancellations, just to explain that just a little bit, this is where you've been noticed that there's a need, or there's registration should be canceled. That's if they haven't voted. We go through the purge process about this time of year of after every general election year. And these are the notices that could be sent by email as well as by mail.
And just to be clear, Ms. Langford, anyone that did not vote in the past election would be getting a notice that they would be purged from the list, or is it past two elections? I can't remember.
After this election, it's after every general election.
Thank you very much. Questions for Ms. Langford? Questions for Ms. Langford? Thank you.
Thank you.
We have a sponsor here. Senator Steinmetz already presented your bill. Did you want to say anything else?
No.
That's fine. Okay, looks like the sponsor thinks it's been covered. Anybody else in the audience wish to testify on this bill? Anybody else in the audience? Is there anybody online?
No, not for this bill.
Okay. Committee, you've heard the discussion, or what is your pleasure? Motion by Steinmetz. Discussion? Not seeing any discussions. Pretty straightforward. How about if we call the roll?
I'm sorry, I missed who moved the last bill. Could you tell me?
Steinmetz moved this one. Was it you, Boner, that moved the last one?
Sure, I did.
Oh, it was Landon. It was Landon.
Somebody over there.
Interchangeable, really.
Thank you. Okay, now, this is a roll call vote on Senate File 165, cancellation of registration notice amendments. Senator Boner. Senator Dockstader.
He's excused.
Senator Landon. Senator Steinmetz.
Aye.
Chairman Case.
Aye. Thank you very much.
4
Okay.
ayes and 1 excused.
Looks like that one passed as well. The next file for our consideration is Senate File 166, Political Party Formation Amendments. Senator Pearson, this has got your name on it as well. How about if you take a seat? Tell us about your bill.
Thank you, Chairman Case and members of the committee. This, just like the last bill, is kind of a cleanup and something that, from my understanding, the clerks were requesting as far as a new political party formation. So basically, it's just bringing the current dates back a month. So from June 1st to May 1st, and then from April 1st to March 1st. And my understanding is that it would give our county clerks more time if a political party wanted to form a new party. So it's just giving them more time to get all of that processed, is my understanding. So it's just a cleanup that the clerks were in favor of, so.
Okay, thank you, Senator. Questions for the senator? Senator Landon.
Thank you, Mr. Chairman. So Senator, thanks for bringing this up. I wonder if you've done any reading and have any notion of how many new parties have even petitioned, or I mean, you just don't hear about this,
No,
so.
you don't hear about it.
Senator Pearson, through the chair.
Sorry, Chairman Case, members of the committee. Oh, Senator Landon.
Yeah.
I haven't heard a lot of political party formations either, but it's in the statute. It allows that option for our constituents to do that. And so I think that this is just, a way for constituents to do it, should they want to form a new political party. And it's just giving the clerks more time to do that processing.
Thank you, Senator. Any other questions for Senator Pearson? Let's hear from the Clerks Association on this. And the Secretary of State. Sorry, I didn't see you there, Mr. Rubino. Clerks can go first if it doesn't. You're both electeds.
Okay.
Representing electeds anyway.
Mr. Chairman, I'm Mary Langford again, representing the clerks and committee. A little bit more about this. I was curious too when this came. This is another cleanup issue from the clerks. We did have a party that tried to form. You ever heard of a party trying to form in Wyoming in recent history? Not really. There was a party that tried to form. And come to find out through that, and I'm going to read you from what the statute and how this is formed, what the problem is with the timing. So 22-4-402A addresses the deadline to file a petition to form a new political party. Currently, the statute says June 1st, but party affiliation changes, remember, crossover, are locked out. Party affiliation changes are locked out beginning on the first day of candidate filing, which is about the 15th of May. If a new party is formed between May 15th and June 1st, no person will be able to register with that party, except the new registrants on election day. So we've got a 15-day spot there that we want to clean up, and that's the reason to move the first date to May 1st, and then the second date that's on page 2 to March 1st. So that it gives you enough time to be able to get the party formed and then to be able to have folks be able to register. And if they wanted to file for that party to run also. So that's that. Clerks have reviewed this bill, and again, this was a cleanup that we proposed as we were clunking through the election code this year, and we'd appreciate support for this bill. Thank you, and I stand for any questions.
Thank you very much. Any questions for Ms. Langford? Any questions? Ms. Langford or Mr. Rubino, can either one of you give us the background of actually how you form a new political party? I mean, kind of more the general. I know it's by petition, and what are the signature requirements? Do they have to be registered voters? All that kind of thing. So if we could do that, maybe that'd be a good overview of before we. Mr. Rubino, welcome.
Thank you, Mr. Chairman. Joe Rubino, I'm the Policy Director and Counsel for the Secretary of State's office. To Senator Landon's question, we did have a provisional party that did file petitions with our office. That was the No Labels political party that filed. Excuse me. They actually informed our office after they had completed the petition requirements and they had submitted their petition for our office. They attained the necessary requisite amount of signatures. It's actually 2% of the total ballots cast in the last race for U.S. House of Representatives. That's how the statute.
Has to be statewide?
For a new political party?
Yeah, 2%.
Yes.
Petition
Yes,
statewide.
yes, that's
Yeah.
correct, yeah. Because those petitions, they're submitted to the Secretary of State's office. You can't have, obviously, you can't have a county political party that's, all of Title 22, we regulate state parties, and then the county political central committees are really subdivisions of the state party. So provisional parties, they follow the same requirements in terms of nomination of candidates that minor parties do. They cannot nominate by primary election. They can only nominate by party convention. So just to take a step back, we are in support of this bill as well, and we appreciate the bringer, Senator Pearson, bringing it. I think that bumping it back a month, it really does no harm, especially if you bump back the petition requirements when you can start petitioning. We didn't run into an issue with this with the No Labels political party. They turned theirs in well before, and that was processed by our office to achieve the 2% threshold. So it was interesting. After they had done that, they informed us in the 2024 cycle that they no longer wish to be a provisional party, but that's not really how the statute works. It's a creature of law. So you form it, that's a political party, and then if it does not achieve the requisite number of votes for certain offices that are enumerated in statute, U.S. House, Governor, Secretary of State, there may be a couple of other offices, but it's kind of a weird collection of offices. If you don't field a candidate, then you just go away as a provisional party. So if you don't achieve the requisite number of votes for a race for a minor party, it's the same thing. So they fell off by creature of statute.
Thank you very much. And then one more general question. When do you become a major party? If you could refresh our memory on that. How many votes do you have to get?
I believe that is 10%, but I may have
10?
to.
I'm trying to remember. The Libertarian Party made major party status a few years ago, but then they dropped back off. And I can't remember what it was. Thought it was less than 10, but.
So,
Senator Landon.
thank you, Mr. Chairman. So, Mr. Rubino, the 2% threshold, if my memory serves, you don't have to get petition signatures from every county, is that right? I think there's a certain number of counties to make it statewide, but it's not like you've got to go out and get signatures in every single one of the 23, right?
No, I think that is the ballot initiative, but Mr. Rubino.
Mr. Chairman, Senator Landon, that's correct. Yeah, the initiative process is different, and that has to have a county distribution. I'll read the statute for the 224402 petition form validity. Subsection D, it says, to be valid, this is for forming a new provisional party, a petition shall contain the names and signatures of registered electors equal in number to not less than 2% of the total number of votes cast for the office of U.S. House of Representatives in the last general election.
Yeah,
Perfect.
yeah.
And I think, just to expound a little bit,
Mr. Rubino.
Mr. Chairman, the requirements for initiative, those are kind of creatures of the state constitution and then further enumerated by statute, so.
Thank you.
Thank you, Senator. Any other questions for either one of the witnesses? Any other questions? Thank you both. Let's see if anybody else in the audience wants to address this bill. Anybody in the audience? Got somebody coming up, I think, or are you going out? No, you're just scooting over. Sorry. Anybody? Online, is there anybody? Okay. Committee, you've heard the testimony on Senate File 166. What is your pleasure?
Move the bill.
Got a motion by Steinmetz. Discussion? Any discussion? Let's call the roll.
This is a roll call vote on Senate File 166, Political Party Formation Amendments. Senator Boner.
Aye.
Senator Dockstader.
Excused.
Senator Landon.
Aye.
Senator Steinmetz.
Aye.
Chairman Case.
Aye.
We have 4 ayes and 1 excused.
Excellent. That's passed as well. The next bill for our consideration is Senate File 181, Eminent Domain Energy Collection Systems 2. And Senator Crago is here. Tell us about your bill.
Thank you, Mr. Chairman, committee. Good morning. Pleasure to be here. Bring you Senate File 181. By the way, Barry Crago, Senate District 22. I always forget to do that. So anyways, this is Mr. Chairman, this is actually a bill draft that we worked through joint agriculture this last time around, and we actually worked 2 bills. And at the very end of working these bills, one was approved by the committee and one was not. And this is actually the version of this bill as it, I think it maybe, if I remember correctly, failed by one vote, but it's one we worked a lot. The former chairman who is on your committee now, her and I worked on this particular draft quite a bit. And so to be honest, what we were trying to do with this particular bill on the energy collection systems was really to find a balance. We did not want to prohibit the use of eminent domain altogether for wind and solar. That was not our goal with this particular draft. It was to try to find a balance between landowner rights, but also the ability to use use eminent domain when absolutely necessary. So what this bill does, big overview, puts sideboards on the use of eminent domain, creates a threshold before you can actually use eminent domain or condemnation. You have to have an 85% agreement with either 85% of the landmass or 85% of the landowners. And so I'll walk you through the bill, but that's the big overview. A couple other things. There's some safety mechanisms built in there for the landowners as we read through it, and I'll explain as I go.
Okay, go ahead.
So, Mr. Chairman, page 2 at the top, currently, the eminent domain is in Title I, Chapter 26, and then it's in the 700 series. And so the very top there on page 2 just notes that for energy collection systems that we're creating a whole new set of statutes in 800 series, and it refers you to that. Then beginning at 126.818 would be the new section. They're on line 10, and it says that eminent domain can be used essentially subject to the following conditions. And those begin on the top of page 3. And that's where it provides that you have to have an agreement, negotiate and have finalized land use and compensation agreements with, and it states the two things I already talked about, 85% of the land mass upon which the system would be built, or 85% of the owners, and it's an either or. And then moving down, bottom of page 3, before you can allege a complaint for condemnation, you have to prove the following, and turning to page 4, you have to prove that you've complied with the 85% threshold, which is there on lines 1 and 2. You have to provide to the court all of the terms and compensation of those agreements. So the court can use that to make their decision for compensation in the condemnation proceeding. And then you have to certify that it's for public use. That's there on lines 11 through 13. One of the things that I was talking about as far as some safety mechanisms built in for the surface owners, that's there on lines 15 through 17. That talks about fair market value and improvements to the property will be included. One of the things we heard testimony about was, for example, fencing or other things placed upon water tanks, et cetera. Those would be included in the fair market value. Moving down lines 19 through 22, that's a reference back to the current eminent domain statutes in the 700 series, and just says that all of those provisions would also apply here. And if you have your green books, or when you look through the green books, as this committee knows well, there's a whole litany of things that you have to comply with when calculating compensation, and this just incorporates those, or that provision. Another one of the safety mechanisms, as I'm calling them, that's built into the bill is at the top of page 5. And there was a lot of testimony during the interim about the use, essentially whether or not this could be used where existing easements are already in place. And so this particular provision says you can use it, but only under, you can use your current easement, but only under limited circumstances. And really this came up because there was a lot of input about old easements. So a lot of the old utility easements, or other types of easements, whether it's pipeline, et cetera, there was a conversation about, well, could those be used for this? There's already an easement. And this is just clarifying that those old easements, unless they specifically allow for collection systems, cannot be used to skirt this particular statute. And that was the idea with that provision, which is most of page 5, lines 1 through 15. The bottom there was just a provision to put in so that it provides notice to your local governing bodies. Some of those, some counties have zoning related to this. This just provides notice. Prior to any action, you have to provide notice to your local governmental entities. Top of page 6, that provision talks about once an order for condemnation is granted, what has to be included in that. And this one is it's also another savings clause or protection for surface owners, because there was also a lot of concern. One of the issues was, well, what happens if one of these collection systems, if we have a wildfire related to that or something, and that's what this particular provision is intended to cover. It wouldn't cover a lot more than that, but that was one of the things that the language within that provision would apply to. And who would be liable for that.
So point that out to me again, would you,
Yep.
Senator?
Yes, sir, Mr. Chairman. Top of page 6, paragraph G. And so one of the issues that was discussed by some of the landowner advocate groups was, look, one of these, you come in, you condemn our property, and your system starts a fire. Who's the liability on? Is it on the landowner or is it on the owner of the system? This is trying to clarify that it would be on the owner of the system, that the landowner shouldn't be responsible for if his or her land was condemned pursuant to an eminent domain proceeding, that they would not be liable for the actions that they had no control over. And that was the intent of that.
Got it. Thank you very much. Keep going.
And then middle of page 6, paragraph subsection H, this section or this new law would not apply to a public utility that has been granted a certificate of public convenience and necessity under 37.2.205. It also would not apply to electric substations or interconnection facilities associated with existing or proposed transmission lines that serve load or that export energy from Wyoming. And that one's a bit of a mouthful, but I think the idea was that if we have existing facilities, we don't want to slow down that progress. If there's something already in place, we're not trying to necessarily make this apply to facilities that are already exporting energy out of Wyoming, that this would mostly apply to new systems. That's the idea.
Committee, any questions on this point? If not, Senator Craico, what if it's kind of, that's an odd, to me, it sounds odd at the very end of that sentence that you're singling out exports with respect to this. And so the serve load is also with the export, right? Serving loads outside or exporting, so it's, so I guess what we're saying with this whole thing is that if the transmission network, the substation, whatever, is serving load outside of Wyoming, it wouldn't apply? Is that a funny exception in the middle of this? It sounds bigger than I think it does when you first read it. Help me.
So, Mr. Chairman, one of the reasons I specifically wanted this bill to come to this committee is to make sure we get the language right.
Okay.
This committee is to be honest, has the expertise in this particular area of law more than the Ag Committee does. And so I'm not sure that the language is right. I get your question. We may
Yeah.
have to clean that up if the bill moves forward. But what we were trying to do is make sure that it provides an economic benefit to the state of Wyoming. I'm not sure that language does that, and I think the former chairman might have something to add.
Okay, Senator Steinmetz, on that point?
Thank you, Mr. Chairman. I think part of it is we were trying to grapple with just dealing with the collector lines and systems rather than interconnection to other facilities. So that's what we were aiming at. If you have a better way to do it, we're all ears.
So most of the electricity is sold, say, to the Rocky Mountain Power network. And those collector lines and all those things go into the Rocky Mountain Power system. It's a shared system. Approximately 85% of the energy leaves the state, but it doesn't all leave the state. There are systems, there's at least one system, as I understand it, that is proposed with no interconnection into the state of Wyoming, and that would be the Chokecherry Sierra Madre. They have their own transmission line. As far as I know, there's not proposals to interconnect in Wyoming, at least not at this time. And so that would kind of fit this being exclusively for export. And yet that situation seems to be eliminated from this section. So that's an interesting thing to me.
Happy
And
to
what are the
take-
implications of that elimination?
Mr. Chairman, and I'm not sure I know the answer, but I,
Yeah.
lean on you in this committee to make sure we get that right.
All right, let's keep going. Thank you.
And then the rest, Mr. Chairman, moving down, page 6, we get into the definitions of what an energy collector system associated with commercial facility generating electricity is. Turning the page, commercial facility generating electricity, the definition for that. And then the remainder of the bill, for the most part, is conforming amendments in existing statute. We have to add one provision in 126.815. But it's also really a conforming amendment for this new section we would be creating. The one thing I would draw your attention to, page 9, section 3, we would be repealing 815D, 126.815D, which is it's the current energy collector system statute regarding eminent domain, which at one point had a moratorium on it and then an extension of that. And so this is just, if this were to go into law, that would be repealed. And then I think it's also important to note the section 4 about which projects this particular law would apply to. If some that have already started the permit process, et cetera, this statute would not apply to them.
Questions for Senator Craigo? Senator Landon?
Thank you, Mr. Chairman. So really appreciate the explanation on the bill, Senator. My question is, it looks like this is a little bit more stringent, and that was the effort of our Ag Committee over the last couple of years. Am I reading that correctly? Is that really the overarching? And I suspect that might be what ran you into a little bit of resistance on the bill. Do I have that?
Senator Craigo?
Mr. Chairman, Senator Landon, I think that's a fair statement. So the bill that ended up coming out of the Agricultural Committee was essentially prohibited the use of eminent domain at all. And this was more of a middle ground. This was an attempt to compromise, not only because there are varying opinions even within the landowner contingency, right? There are certain landowners that want to be able to put a wind farm or solar panels on their property. And this is something they may have to use at some point if they want to do that. But they also want to protect their neighbors to some extent. So this was an attempt to try to make that doable without prohibiting the use of eminent domain altogether. So hopefully that answers your question, but it does, but I will say this, it's obviously the way the statute's written now, there really aren't a whole lot of sideboards. This provides sideboards. It does provide more protections for the landowners. And I know there's some things in here that industry probably doesn't like, but it's better, in my opinion, it's a better policy decision than prohibiting it altogether, which is why I'm bringing the bill for discussion.
Senator Landon.
Appreciate that, Senator. Thanks. That helps. Thank you.
Senator Steinmetz.
Thank you, Mr. Chairman. Just to add on to that, it wasn't a complete prohibition. It was just a prohibition by private companies. Public utilities could have still used eminent domain with the other bill. So this is kind of the compromise position. The committee chose to send the other one forward and start it in the House. However, this was the more middle ground bill that we worked, so it's not as stringent as the law now. It's a little, it's tightening those up for landowners and for private property rights. It's a step toward that, but it's not as stringent as the other bill.
Thank you, Senator. Senator Boner.
Thank you, Mr. Chairman. Just a little bit more discussion about how the committee landed on the 85% number and the 3 landowner minimum. That, a lot of these collector lines, they're not like a big interstate pipeline or transmission line. They're probably 20, 30 miles, and so just wondering, how we land on that. And it seems like, frankly, they don't really match up very well. Shouldn't they at least be divisible, maybe like at 80% with a 5 landowner minimum? Because I can see that the minimum amount of landowners being right in that neighborhood in many parts of the state. So a little bit more discussion about how you all arrived at those numbers.
Senator Craigo.
Thank you, Mr. Chairman, Senator Boner. So there's actually this really smart guy sitting behind me who sort of proposed that idea to us, and you'll get to hear from him in a minute. And it's an idea I think he had been working on for quite some time. Those numbers, I don't believe there's a whole lot of science to that. That's just, a feeling of the committee that was a reasonable number. Those are not set in stone. If we like different math, let's go with different math. There's no rhyme or reason other than we just felt like that was a good threshold. It's enough to where the industry would have to go get quite a bit of support for their project. But the thought was, if there's one landowner in the middle of a 20-mile transmission line, they couldn't hold up the entire project, really. I think that's what you'll hear from the testimony.
Okay, anybody else? Senator Craigo, could you help me by going back just a little bit to that discussion we had on page 6, Romanet 2 under H? So there are H has 2 exceptions that say that this section shall not apply. And so I assume by section, we're talking about the 85% rule and the other requirements you're proposing in this bill, right? That would be this section. So that kind of says this bill shall not apply to a public utility. It's got a convenience of necessity. And also seems to say that this bill shall not apply to electric substations or interconnection facilities associated with existing or proposed transmission lines that serve load or that export energy out from Wyoming. So if they don't interconnect in Wyoming, it sounds, and they're proposed, it sounds like they're not covered by this act. Doesn't say anything about whether they started permitting or anything, they're just proposed. That's kind of out there. Tell me about that.
Mr. Chairman, I do not remember how we got the language proposed. The existing makes total sense to me.
Totally.
The proposed one, I do not remember how we arrived at that particular language. I mean, looking at it, if I'm just off the cuff, if I'm remembering it or not remembering it, but thinking about it correctly, it would be, we're not trying to stop projects that are in plan. Maybe they haven't started permitting, but there are plans in place. They're working towards that, and it may have been to, stop any sort of projects in their tracks, right now. That's a pretty wide open word. I agree with that. Again,
Okay.
we might need to clean it up. I don't deny that.
All right, thank you very much. Any other questions for Senator Craigo? Stay close, Senator Craigo. We'll go through the audience. Who's next in the audience would like to testify on this bill? Who's next? Yes, sir. Commissioner, welcome. Mr. General Counsel. Good to see you, Commissioner Robinson. Mr. Burbridge, welcome.
Morning, Mr. Chairman, members of the committee. We just have one comment that relates to potential, what we see as an ambiguity that may have unintended consequences.
Yes, sir, you go right ahead.
And that's on page 7, and it's lines 8 through 11, which is the definition of commercial facility generating electricity, which it defines as any commercial plant, property, or facility generating electricity from any source for the purpose of selling electricity at the retail market price. And it's that last phrase on the end of line 11, at the retail market price.
I see your concern, yeah. Tell us more about that.
So I would note, as you've already discussed, Mr. Chairman, on page 6, public utilities are excluded from this. Now, public utilities are the ones that sell at the retail level. And so if this is intended to capture merchants, you may not be doing so by referencing retail market price.
I get your point exactly, Commissioner. Questions for the Commissioner? Yeah, I'm not sure that we need to have any price adjective relating to what a commercial facility generating electricity is. I'm not sure it's relevant what the price is. That's one of your points, I think.
Yes. Yes,
Yeah.
Mr. Chairman.
Okay, we'll take that up. Mr. Burbridge, do you have anything? You were just giving him moral support.
I'm just tagging along, Chairman Case,
Well, it's good to see you. Thank you.
in case things just totally fell apart, which I was confident they would not.
Well, it's still early. Thank you very much, sir.
So true. Thank you.
Yeah. Who else would like to address the committee on this bill? Who else, please? Yes, let's get Mr. McGagnon, and then we'll go over to you, ma'am. You might as well both come up. Mr. McGagnon.
Thank you, Mr. Chairman. Jim McGagnon with the Wyoming Stockholders Association. I have a history with this bill that goes back to 2010, when the issue of the use of eminent domain for wind energy collector lines first arose. And the legislature, we worked the legislature at that point and put a moratorium on use of eminent domain. That moratorium was later extended. But at the same time, the moratorium was put on with the idea that give us a couple of years and we'll develop some workable legislation. This bill with a few changes now is basically what we developed in 2011 and 12 to move forward with. Then the use of, or the development of wind energy sort of had a hiatus in Wyoming, and for that reason, the bill was never pursued until the Ag Committee began to take this issue up last year, and we brought this bill forward to the committee, and it's basically with some cleanup the same bill. The one significant difference that I would note in the bill that we had drafted back then, it was not 85% of the landowners or 85% of the land, it was 85% of both. So it was a little more stringent in terms of what it took in order to authorize the use of eminent domain. But that was the purpose of this. With regard to a couple of specifics, Mr. Chairman, just based on having worked with the bill before, the questions that you raised on page page 6, lines 14 through 17, and I'm certainly not implying that this can't be strengthened or clarified, but the intent was that this would apply or would not apply to, was intended to apply to collector lines. That's the definition used in this bill several times, not to transmission lines that after that collector point takes electricity to a substation, then it goes into a major transmission line. This is not intended to apply to those lines, irrespective of whether they're transmitting for an in-state load or for export. And the language there was intended to exclude those major power lines irrespective of it. So serve load, it doesn't say where that load would be, either in the state or outside of the state, or that don't serve a load here but strictly export energy. So The intent of that language was to cover both in-state and export. Perhaps that needs to be strengthened, but I would just point that out to the committee. But it is a little confusing as you read this bill because it references collector lines so many times.
Right.
But then uses some other language that, if you don't draw that distinction, would appear to imply that it's something other than collector lines. But that's the intent of the bill, is to apply to these collector lines. As far as the percentage, Mr. Chairman, members of the committee, that 85 was what we came up with back in 2011. And while we strongly support this bill and feel it provides that right balance, the percentage is something that is open for discussion and always has been open for discussion. It's just the original percentage that was offered in the bill. But our support for this bill is based on the fact that however we may feel about these types of energy, property rights provide that a landowner may put wind or solar energy on their property, particularly wind has been the primary one in Wyoming, if they so choose. And if the power companies are able to negotiate with the adjacent landowners in a fair manner for compensation for these collector lines, we feel that perhaps one landowner who only has a small amount of the line on his property or her property should not be in a position to infringe on the property rights of the 85% in this case, to enter into an agreement that they've all found to be agreeable and acceptable to them. So it's trying to find that balance between, we didn't support the bill for absolute prohibition on eminent domain because we felt that that had the potential to infringe on the rights of a lot of people who want to negotiate for the use of their land. And I would point out to the committee that wind energy in particular has become, frankly, a saving feature on keeping many Wyoming farms and ranches financially viable and able to continue their ranching operations as family farms and ranches. And for that reason, we strongly support this bill. Mr. Chairman, I'd be happy to take any questions.
Thank you, Mr. McGagna. Any questions for Mr. McGagna? Senator Landon.
Thank you, Mr. Chairman. Mr. Regagna, thank you. Appreciate having an expert with us on the land front. That language, the 85% language, can you help me understand what the difference between 85% of the land and 85% of the owners of the land? Can you help me understand what, I can't quite get my arms around.
Mr. Chairman.
Go ahead, Senator.
Is that just one landowner? Help me with that. Thank you.
Mr. McGagna.
Mr. Chairman, Senator Landon, since the collector line may have to go across significant landowners in order to reach a substation, it may be that one landowner, just to use an example, controls 90% of that land, but another landowner who only controls 10% is unwilling to negotiate on similar terms for the right to cross that land. So that's the one case where you may have the landowner that owns 85% of the land, but is only one out of 10 landowners that are involved in the project. So the 85% of each would mean that you have to, or the either or would mean, as it is in this bill, would mean that if there are 10 landowners and one of them controls 90% of the land, you either have to get that one with their 90% or you have to get 85% of the number of landowners involved.
Thank you for that.
Got it? Senator Boner.
Thank you, Mr. Chairman. Along similar lines, I heard you said that's the number you came up with in 2011. But can you tell us why that's the number? I think we need a justification. My concern, Mr. Chairman, is that if the goal is to make sure that no one person can stop a project, that this, I'm not sure if that gets us there in many parts of the state. You need at least 7 landowners to reach that threshold, if that makes sense, at 85%. So if you have one landowner out of 7, for example, then that's only 14% of the overall amount of landowners, right, on the collector line. So I'm in Commerce County, that's you probably don't cross 7 landowners to get to the transmission source. So I'm really concerned about this number, that we don't have it right. So I think it's really important that we justify it.
Mr. McGagnon.
Mr. Chairman, Senator Boner, I can't recall exactly how we got to the 85%. It was a negotiation process that involved the one or two renewable energy companies that were involved in Wyoming at that point in time. Those of us from the landowner, representatives from the landowner industry, and the then chair of the House Ag Committee, as I recall, we all sat down together over several meetings and went back and forth on it, and that just seemed to be a number that everyone felt was equitable, that if you didn't get at least that amount, you shouldn't have the right of eminent domain, and that if you got 85%, that's right. There was discussion of 95%, I do recall that, but, and some who wanted 75, and this was just trying to find a common ground.
Good. Anybody else? Mr. McGagnon, can I ask again, back to page 6 on the bill and the exception that's in that, and you mentioned that you thought that any transmission line that goes out of state should have an eminent domain, and clearly, and you shouldn't have to do the 85% rule, but we're really talking about collector lines. But then you mentioned this electric substations. And so those electric substations are pretty big entities, and they're going to get bigger in the future as we have more desire to control power flows, maybe have more DC in the network. You know, I was in Germany on an energy tour, and like in the city of Hamburg, they have to replace 50 substations, but the footprint of the new substations is 3 times what the old substations were, and that's to accommodate renewables in the grid. It's astounding. You know, you have to, and the substations are acres in size, so they've got this huge job ahead of them. So where you put a substation, I mean, that has a lot of implication for the landowner, but according to this, it'd only be the collector lines, and when you get to the substation, they get to use eminent domain to put the substation wherever they want. Is that really what you meant?
Mr. Chairman, I think the focus here was very narrow, admittedly, and feeling that the current eminent domain laws that we have in the state adequately or generally address the transmission facilities, the substations, and the interconnection facilities. And the issue that arose that we were dealing with at that point in time was simply these collector lines that go from the renewable energy facility to those substations, feeling that that wasn't a process we want to become involved with. And I would simply say at this point that that may be an issue that is worthy of some consideration at some point, but I think there are enough differences that we would suggest that this legislation to deal with these collector lines be dealt with separately, and that be a subject for future legislative consideration if deemed necessary.
Okay. It is in the bill title that it's energy collection systems. I guess it's whether you consider a substation to be part of a collection system or not. That's a good point.
That's true, Mr. Chairman.
Thank you, Mr. McGagnon, very much. Ms. Bud Phelan, how are you?
I'm good, Mr. Chairman.
Go ahead.
My name is Karen Bud Fallon. I am an attorney and owner of the Bud Fallon Law Office with my husband, Frank. Frank and I rise in support of this bill. We actually worked with the Joint Ag Committee when they were discussing these bills and trying to figure out, what's the best way forward on this. We support this bill because we have represented hundreds, maybe close to thousands of miles of landowners who either negotiate with transmission companies or collector line companies. We've also represented, I would say, thousands of acres of landowners who have agreed to wind contracts on their property. If you're going to build a wind farm on your property, which cannot be condemned, so it has to be a fair negotiation with the landowner and the wind company, the wind farm is not going to happen unless you have collector lines to get you to a transmission line. That is simply the reality. And so putting on our hat of saying we're going to represent the rancher or the landowner who wants a wind company and he wants those towers on his property, that's his property right. and he can fairly negotiate that. But his neighbor, who said, I don't want wind towers on my property, has no chance to say no when they come in and say, okay, now we're going to put a collector line across your property. We could condemn for that. The only thing in the condemnation they consider is price. They don't consider things like reclamation when they put up the transmission or the collector line. They don't consider remediation. Things like liability are not covered in the Wyoming eminent domain statutes. And I'm not suggesting with this bill that we add all that other stuff in, because I think it'd be, a 30-page bill and would take massive amounts of study. But what we're trying to do is help the landowner that wants towers on his property or a solar farm on his property, but not to the expense of his neighbors that are like, we're not really excited about this. And so this bill is a chance to say, okay, I'm a landowner, I'm gonna put wind towers on my property. You have to negotiate with my neighbors to come up with a fair price, to deal with liability, to deal with reclamations, all the things in a contract. And if you've got the one grouchy landowner in the middle, and there are those grouchy landowners in the middle in Wyoming who just are simply not gonna deal with this, we don't want them to stop the private property rights of the guy who wants the wind towers and the people that have fairly negotiated contract. So this is a sort of a negotiated settlement. We were trying to keep all worlds happy so that you could choose to put a wind tower on your property if you want. Quite frankly, we're not gonna put wind towers on our ranch, but if our neighbor wants to, the only way I should be able to stop that is to buy their ranch, not to just say no. And so we're trying to really split that baby in a fair way in Wyoming. The one place that I would point out in the statute that hasn't really been, or the bill that hasn't really been talked about, is I think the language on page 4, lines 19 through 23, and you'll see I did better this time. I got lines on my, line numbers on my bill.
You're learning.
Figured it out. That language is in reference to a Supreme Court decision, Green Corps versus Barlow. And then Wyoming legislature codified that in statute, which I think is really important. And so we wanted to make sure that those compensation language was included with this and not just general condemnation, which is basically fair market ag value. That's also why they included things in here like, you've got to consider fences or improvements on the property. Because what you're really doing is you're condemning ag land for an industrial purpose. And the landowner should get compensated because you are changing the use of his land. You put transmission on his property, you put a collector line on his property, you are changing that property, and we wanted recognition for that.
Can you repeat the name of the case at the Supreme Court? Green Corps?
It's Green Corps,
Green Corps.
yeah, versus Barlow, or I may have the.
Now, one of our Barlows,
Green Corps?
That's correct.
Okay, I couldn't remember if it's Barlow versus Green Corps or Green Corps versus Barlow. But that is a case that actually dealt with compensation on eminent domain, and what the court said is that it's not just appraised value of the property, that you also have to consider what the landowner has, like if he's got other transmission lines on his property, what he got paid for those. If he's got other pipelines on his property, what he got paid for those.
Got it.
That's included in the consideration of fair market value. It's not just appraised value.
okay.
We want to work hard to keep that compensation mechanism in this case, or in these eminent domain statutes.
So I think your point is that case kind of framed existing compensation, and this whole section 19 through 22 keeps the current eminent domain statutes with the existing compensation thoughts in it.
Yes, Your Honor, I'm sorry, yes, Chairman.
Thanks a lot.
I'm used to courts, I apologize.
No, it's perfectly fine, thanks.
Don't elevate it like that.
Yeah, it's a bad idea. Any other questions from the committee go ahead, Senator Landon.
Okay, yeah, Ms. Bud Phelan, thank you very much. Really appreciate the testimony on this front. I'm just trying to get over a little sense of unease that maybe we're putting this bar a little bit high. Things have changed a lot since 2011. A lot of our ag producers, as we heard in testimony a minute ago, have gone in this direction. It's really done well for a lot of our people. If we put this in place, are we prohibiting future ag producers from enjoying the same benefits of production of electricity on their land? I'm just trying to wrap my arms around that. I want it to be stringent. I totally get that. But do we have any worries? Is there any concern on your part that this may prohibit one landowner who can't quite, he can get to 75 or 80%, but he can't get the 85%, so he cannot benefit from development of his land? Any thoughts on that?
Ms. Bedfallen.
Chairman Case, Senator Landon, I was not around, well, I was around in 2011, but I wasn't part of the discussion. If the percentages need to change, it's 75% or 90% or whatever you think is adequate, we don't have any problem with that. But we don't want it to be like it is now, because now, and for as many stories as industry that can tell about, oh no, we work with landowners, I represent the landowners. I can tell you just as many horror stories on the other side. So getting into telling horror stories is not really useful, I don't think, for you. But if the percentage needs to change, I think that's fine. I'm just also trying to protect the landowner who doesn't get the very lucrative benefit of the wind tower because he's only got a transmission line. I'm trying to protect him as well. And so this is the compromise that we came up with. And if we need to change the percentage, I'm happy to talk to Mr. McGagnon, who works with Wyoming stockgrowers. He's going to know lots more of those people than I would. We can certainly provide information to this committee or Mr. McGagnon on, based on our landowner groups, what we think of percentages. We're happy to do that.
Senator Landon.
I appreciate your thoughts. Thank you. That's helpful.
Yeah, and then Senator Landon, I think you can park in your mind, and we all can, that when Mr. McGagnon was testifying about the earlier bill, that was 85, whatever is the lowest. This is 85, but it's either or. So that is a big difference. It's a lot more flexibility if you think about it. Okay, anything else, Ms. Budvalo? We're good?
No, I would stand for any other questions that you have, Chairman Casey.
I don't think we have them right now, but stand by. Ms. Delancey, welcome.
Good morning, Mr. Chairman, members of the committee. My name is Cindy Delancey. I'm here on behalf of American Clean Power, as well as also wearing my hat as a landowner and rancher. My husband and I have a family ranch in Platte County, and there's a lot to unpack here based on this discussion. You know, it's first off by saying, Mr. Chairman, it's a great honor to get to sit at this table with my colleagues who I admire very much. However, today, unfortunately, we disagree on some of the positions. They are speaking in support, and unfortunately, I'm speaking in opposition. Senator Landon, you're correct, exactly correct. You know, there's a lot going on here as far as if this bill were to pass in its current form, the net effect would basically mean that eminent domain is off the table. And therefore, these projects can't go forward. And therefore, as you said, you know, the ability to benefit and keep our ranches whole in Wyoming goes away. And let me just talk you through why I make that statement that this bill, if it moves in its current form, the net effect is no eminent domain. Really, this is, a solution in search of a problem. Our current eminent domain statutes are very, very thorough. They have a good balance between the landowner and industry. I want to just reiterate through the testimony that you've heard, the landowners in Wyoming are very, very sophisticated people. They have very, very talented attorneys, like my colleague sitting to my right here. These are not people that are being preyed upon and pushed into a predatory situation with the current legal structure in place to protect them. So just kind of starting through this whole discussion on page 3, Mr. Chairman, related to the 85, or 85 or 85, the math simply doesn't work. It would need to be something more along the lines of 50 or 50, because again, for 85 to work, you'd have, to Senator Boner's point, 8 landowners. It doesn't work if you have just a small number of landowners, which is where these situations usually pop themselves up, in a place where you maybe have, 1 or 2 landowner. And if that, again, with the math being the way it is, which I think we can all agree upon in, its current format, 85 or 85, even though it's well-intended, the numbers still unfortunately don't work that way. So moving on, so that's kind of issue number 1 that I think is, really a major problem with the bill in its current format. Also moving to page number 4, related to lines 19 through 23 that Ms. Phelan was describing. Although well-intentioned, what this language would do by having this included is it would set the person up to be in violation of the contract terms that require that this information remain private. The discovery process and litigation is how this is addressed. And really the only thing that this does is it puts, again, somebody in violation to be, to be inviolative of their contract agreement terms. And it also promotes anti-competitive behavior, which is really not what we want in Wyoming to be doing. The process through the court is all, the statutes are clear already on this process. And to put this in just really adds just another element of complexity on what does a person do, follow the statute or follow the agreement, and it just again is another element of uncertainty and
Would you
clarity.
back up and tell us
Certainly.
exactly where on page 4 you're referring to?
Yes, Mr. Chairman, thank you. I'm sorry if I'm just trying to whiz through this, as I know we have another lengthy discussion to have this morning. Line 19 through 23, which is the language that would.
That's the current language, right?
This is the language that was added in this new section, Mr. Chairman.
But it brings in the current requirements, right?
Yes, Mr. Chairman, yes.
So I didn't get what you meant about it publicizing private agreements, is that part? Can you help me with that?
Certainly, Mr. Chairman, it takes the existing language and builds upon it. It expands existing language. And that's where it would be forcing outside of the discovery process, which is through litigation,
Right.
that it would just automatically set somebody up to make sure, to kind of make that information known, which is usually confidential in the agreements
I see what
related
you're saying.
to the level of compensation. And that's where the concern of promoting anti-competitive behavior becomes, which is bad policy, Mr. Chairman.
Do you know how it works with utilities? If a utility uses eminent domain, is that information public? Is it any different for utilities than anybody else?
Mr. Chairman, I do not have that answer, but I know the members of the Public Service Commission will certainly have that answer, so I defer to.
We can do that.
I defer to someone smarter than me on that topic. So just kind of moving forward again in the
Okay.
essence of time, Mr. Chairman. Moving on to page 5. I know you all remember and you know that at heart I'm absolutely a proponent for local government, wearing my former hat with the county commissioners. But unfortunately, again, this is a place where my colleagues and I part ways with subsection F on line 17. There really is there's no necessity or benefit by giving notice to the county commission in a situation like this. This section, all it would do is inflame. And the commissioners, the government, in my perspective, on behalf of industry, really has no place in a 2-party contract to make it a 3-party contract, including the arm of the state. So, if this bill were to move forward, I would ask that lines 17 through 22 be stricken, as again, this is a two-party negotiation, not a three-party, and there's really no authority that the county commissioners would be able to invoke in a two-party negotiation.
I think it was presented that that might be involved for zoning requirements or things like that.
Mr. Chairman, if a transmission line is, or collector lines are being contemplated, clearly zoning will have been vetted out and verified before we get to a negotiation between, a condemnation statute or proceeding, I'm sorry, Mr. Chairman. So there's really no need for the commissioners to be weighing in on zoning, knowing that these projects are not being built, within, an area that doesn't provide for such. Many of our counties in Wyoming have areas that are essentially open, agricultural that permit this, particularly in Senator Steinmetz County, that it's just an additional layer that's burdensome, to the process, unnecessary, and just designed to inflame.
Okay. Senator Steinmetz, question on this point?
Yes, thank you. So with reference to my county, we don't have the zoning. And some counties across the state don't. And this kind of development is just coming into our county. So I think this notice is quite appropriate, and I think our commissioners would appreciate it because it's been a little bit like being run over by a steamroller in some aspects with the solar projects that have been proposed.
Thank you, Senator.
Thank you.
We'll have more general discussion on the bill, but appreciate your point, Ms. Delancey. Keep going.
Thank you. I will keep going, sorry. Page 6, this line 5 with the requirement, of reclamation. Mr. Chairman, this is duplicative and potentially in conflict with 126-114, which already speaks to the reclamation provisions already provided in the process. So again, this is just another element of uncertainty and being unclear as far as how we navigate which area in our statutes would control the requirements in the process. And really, Mr. Chairman, this is the heart of my concern with this bill is on page 6, line 10 through 12. This is the one that you touched on as far as exempting out public utilities. I know that we've heard that there's horror stories on both sides of this, but when you look at the evidence, there is no independent power producers exercising eminent domain in the state of Wyoming at this time. The people that are doing this are the public regulated utilities. And if the purpose of this bill is to give everybody an equal footing, why would we want to exempt out the only people that are exercising eminent domain at this time? So, just a little bit of background. A better solution could be, I think what Ms. Fallon was saying earlier about the good faith negotiation, I think if we're looking to improve that process, bringing this bill is not the solution to that. A better solution, in my opinion, Mr. Chairman, would be to further define good faith negotiation and really what that means in Wyoming Statute 126-509 to 510 subpart C, where that good faith negotiation, because I think where this originates from is that, that the public utility sent an initial offer letter to the landowners in a recent proceeding related to this. And what that essentially meant is that the landowners were immediately under threat of condemnation before any negotiations took place. If indeed that's true, by defining further what that good faith negotiation truly means in Wyoming, that is a better place to address that problem as opposed to bringing all of this down with all these uncertainties and all these complexities that truly at the end of the day are just going to really force us all into court to have this sorted out, which is in nobody's interest. So that, if this were to move forward, Mr. Chairman, striking line 10 through 12 on page 6, exempting back in the people that are actually, essentially doing this would be the way to really get at the heart of the issue as opposed to having this apply to people who are not exercising this practice at this time. Think that's about it, Mr. Chairman. I know, again, that's a lot to unpack here, but I appreciate all the work that's gone into this bill. Working with Senator Craigo is always a delight. I know he has everyone's good intentions at heart. I just wrap up and conclude, Mr. Chairman, by saying, I just don't think we're quite there yet. And to jeopardize, an industry that's already producing 22.8% of all the electricity being generated in Wyoming, investing $8 billion of capital investment in wind and solar and energy storage projects in Wyoming, investing $21.7 million in our local governments through taxes, investing $21.9 million extra income to farmers, ranchers, and other private landowners in Wyoming, to run the risk of that all going away because of these uncertainties. To me, it just feels that maybe we need to spend a little more time analyzing to get this right, and I'm not sure this bill in this draft does it. So with that, Mr. Chairman, again, I stand in opposition to this. I'm happy to work with the partners. We've worked on complex issues in the past, and I'm certainly willing to roll my sleeves up and come to the table in good faith to try to get it right for all. So thank you very much.
Thank you, Ms. Delancey. Questions for Ms. Delancey at this point? Thank you very much. Let's get some other folks up here that want to testify. So just by way of a little housekeeping, I didn't realize the other day when we had a similar bill and all three members of the same law firm testified. That seems a little bit unfair. I know you're but maybe there's a different aspect to this, but I was sort of caught up in the fact that, three lawyers in a row, and Ms. Delancey didn't bring three lawyers. I'm sure she's got three lawyers in her shop. I'm just pointing that out, trying to be fair. So, but think about that, and we'll start with Mr. Moline.
Mr. Moline, I apologize for that chairman case. Brett Moline, Wyoming Farm Bureau Federation. I think this bill goes in a correct direction. Instead of, it's been said, well, one person can stop a project. Our current situation, one person can force a project. And that's, you have to dance around the issue to be able, it's tough. I truly understand that. I think this bill goes the right direction. To Senator Steinmetz's comment about not all counties have zoning. So I think that's important to keep in the notice to the county commissioners to let them know what's going on, especially, and I don't know if that needs to be reworded into, the counties that don't have zoning, but I think it's important to keep the government closest to the people in the loop. One part that does give me pause, Mr. Chairman, is on page 4, lines 9 through 10, and I apologize, I missed the discussion. I was in another committee. But with all the terms and considerations having to be disclosed, one of the concerns I have is about the confidentiality of those agreements. It has been said that, these are, if it's a negotiated agreement, it should be confidential. And I have concern, and I'm not sure that with what's on lines 4 through 9, that assurance is there. As one of my members said when we were working on this issue several years ago, I'm a better negotiator than my neighbor. I can get more than my neighbor, than other people can, but I don't want them to ride on my coattails, my ability to negotiate, and they get the same things that they didn't have to negotiate from. I mean, it's, again, it's a kind of comes down to a private property rights issue that your agreement should be confidential. With that, Mr. Chairman, I would sit for any questions.
Okay, Mr. Moline. Senator Boner wants a question here.
So, thank you, Mr. Chairman. I mean, I think it's really important, frankly, that these provisions are in here. That's what guarantees that we don't make things worse for the landowners, given the precedent with the Barlow versus Green Corps. That was actually really important. And one of my concerns with previous iterations of this bill is that, you have a tendency of putting that at risk if you don't include these provisions. And so, I'd urge you to think a little bit more about that, Mr. Moline, that we don't want to inadvertently make, take landowners backwards here. So I think it's a balance there, and, I understand the confidentiality concerns, but then again, there's a, I think, compelling reason for that to be in there. Do you have a response to that?
Mr. Moline.
Mr. Chairman, Senator Boner, I understand your concerns, but I hope that you also understand our concerns that, if we have a voluntary agreement, I understand it being disclosed to the court. But I would hope that we would have assurances that would not be subject to public information acts, et cetera, that if it remained with the court and did not go out to the general, that anybody could have access to it, that would satisfy my desires. Trying to be direct on that answer, sir. I hope I answered your question.
Okay, thank you. Keep going. Did you have anything else?
No, Mr. Chairman, I do think this is in the right direction. I do have to agree that with the previous statement that who's ever doing the collector line should be subject to this, regardless if it's private entity, public, who's ever doing it should be, we should all be on the same playing field.
So that would include public utilities?
Yes, sir.
Thank you very much. Any other questions for Mr. Moline? Thanks, Mr. Moline.
Thank you, sir.
Mr. Nicolasian, how are you?
Good morning, Mr. Chairman. I'm well, thank you very much. My name is Peter Nicolason. I don't have my brown badge on me this morning. I'm a county commissioner in Natrona County, but I'm not speaking on behalf of the WCCA. The WCCA has not taken a position on this bill.
Okay.
I am a landowner in Converse and Natrona counties, and our ranch has had on it since 2009 a 100-megawatt wind farm originally constructed by Duke Energy. Now it's owned and operated by a company called Deriva Energy. I've also been an attorney practicing in the real estate and contract realm since 1997, although I did retire about a year ago. I've represented a number of landowners over the years involved in condemnation proceedings, and so I'm very sympathetic to what is or what was typically a very unequal bargaining position. We always went to court focusing in on the good faith requirements of existing statutes and case law, and it was always a matter of degree or interpretation whether or not that had been obtained and done actually in good faith, rather than just, an offer being thrown across the table and then trying to force, if you will, point a gun to the head of the landowner. We also commonly saw problems with the compensation. I think that has been addressed by the Wyoming Supreme Court in that Barlow case, provided some clarity in that respect. I'd like to turn for a minute, though, to the specific situation that exists on our ranch. So all of the generating units are located on our deeded property. There is a substation on our property, and then there's a transmission line that runs for about 4 miles to the south to the point of interconnection. That transmission line is primarily on one landowner. And in this case, it's an existing transmission line, existing wind farm. But the transmission line only has a 20-year easement. It's not a perpetual easement. And so there is certainly potential impact for that existing facility, which of course, as you understand, was an industrial siding council proceeding, $200 million plus project. And I think that we really ought to look more carefully at the exemption language in subsection H. It says it shall not apply to a public utility. That of course is not the situation in our case. The power is sold to Rocky Mountain Power at the point of interconnection. That subparagraph 2 says electric substations or interconnection facilities associated with existing transmission lines. I think that it's problematic in that it's pretty narrow, and I think what it should say is energy collection system associated with a commercial facility generating electricity, because as I read this language, I don't see that it actually applies to the transmission line in between the
agree with you.
interconnection, point of interconnection, or what's called the switching station, which is on the neighbor's property, and the substation, which is on ours. So I think that clarification and protection for these existing facilities needs to be more robust, and that's a specific change that I'd suggest would be appropriate. I think that if, and I'm not a math guy, I was an attorney, but when we look at 85%, and then it talks about not less than 3 landowners, that, and I'm sorry, I don't have the page and line in front of me, but basically in B1B, we see 85% of landowners. Well, if we have 10 landowners, then that's actually not 8 landowners that have to agree. That's actually round up to 9.
Yes.
So you could have one landowner that could get in the way despite negotiations in good faith. So if it's going to be 3 landowners being the minimum, I think that 66% or 2/3 would be a more appropriate number. I think, though, my feeling, and I think this is consistent with what Ms. Delancey said, that maybe you just have a majority, 50%. And then you've kind of established that you have worked in good faith, at least with those. And then moving forward, if you have a majority, then the rest can move forward. So I think that 85% is too high. Those are all my comments. Are there any questions for me?
Anybody? Mr. Nicolais, and I really appreciate you being here. Suppose it was like a 50% threshold, and then the terms and conditions that are voluntarily are reached with the first 50%, would they become the basis for the terms and conditions for the imposition of the eminent domain?
Mr. Chairman, thank you. Not necessarily. I think that a landowner, that those last 49% of the landowners certainly should have the opportunity to say, well, our land's different, because as we know, all real estate is different. So maybe
Could be more.
Maybe it's crossing a river, maybe it's crossing more fragile land. So I think that might be a relevant point to the good faith requirement. But I don't think it should be either a baseline or a cap. I think that they should have the opportunity to present their evidence that it could be a much different number.
Okay, thank you very much. Any other questions? Senator Landon.
Thank you. Just real quickly, Commissioner, it's good to see you. Thanks for coming down. How do you feel about that notification
to the county
language in the bill to the county commission? You think it's good, bad, necessary, helpful, not necessary?
What do you think?
Mr. Chairman, Senator Landon, thank you again. I'm not speaking on behalf of the WCCA or on behalf of the Detroit County Board of County Commissioners. I would say that in some circumstances, maybe it's the limited mining operation arena, maybe it's a school section that's in close proximity to a municipality and hundreds of residences. But I think notification is extraordinarily useful. Because I think that the commission could have valuable insight to, for example, in that case, the State Office of Lands and Investments that hear the concerns at a local level from our constituents. I tend to agree with Ms. Delancey, though, with respect to a court proceeding in a condemnation case. It really is. It's hard for me to imagine a situation in which the input of the Board of County Commissioners would be relevant to the legal questions and factual questions that are being determined by a judge in a condemnation proceeding. So what would we weigh in on as commissioners? So I don't mind having notification of it, and maybe I can be the camel with my nose under the tent. I don't know that that's appropriate or relevant. So to me, it's not harmful, but it's not helpful.
Fair enough.
Thank you for that.
Senator Bonner.
Thank you, Mr. Chairman. Just, further along those lines, it seems like this sort of activity is going to be covered by the Industrial Siting Council process. And so I guess you could answer as an attorney or as a county commissioner, but is there not already notification in general that to the county commissioners that this sort of project is occurring?
If you can.
Mr. Chairman, Senator Boner, thank you. Well, clearly there's notification at the onset of that Section 109 proceeding in front of the ISC, but and if there are certain modifications to that facility, then additional notification, there is a process for that. This may not rise to that level. I don't think that the division, the industrial siting division, is required to be notified. This isn't my legal opinion, but in the event of a condemnation case or some sort of transmission line dispute between a couple parties.
Thank you. Are you still a member of the bar?
I am.
Good. You might get some work later, even though you think you're retired. Anybody else? Thank you. Time out for housekeeping. We're not going to get to the last bill, Senate File 183. There's just no way. And so appreciate you coming for that, but we will take that up on Monday if that's the only reason you're here. Okay, to you. I'm sorry, I don't remember your name from the last time.
No worries, Chairman Case. Connor Nicholas.
Connor Nicholas.
Allen offices.
Yeah.
I'm not going to pile on, just as you suggested. I think most of what I wanted to do, I'm going to turn off a few of these mics here.
That's a good idea. Thank you.
I think one solution that could potentially be helpful when it comes to the percentage is that we already have a percentage requirement for unitization of minerals and pore space. That percentage is 80%. It is successful. It has worked. I represent landowner group for Southeast Wyoming for the Tallgrass project. They have successfully accomplished that 80% threshold. That threshold also requires that if you can't meet 80%, you can request for 75% requirement with under special circumstances. So that would be a potential solution. It's one the industry has worked with in the past. It has worked. It would, once again, still be a stringent requirement, but it would be a requirement that industry should at least be able to accomplish because they have. So that would be one solution we would, that I would propose if we want to follow behind what we've already done in the state. If we did that, that maybe perhaps provides the justification that Senator Boner had asked for earlier.
Okay, thank you. Questions? Any questions for Mr. Connor Nicholas? Thank you. Thank you very much. Who else would like to testify on this bill? Anybody else in the audience like to testify on this bill? Got somebody coming forward? Hello, welcome. Go ahead.
Good morning, Chairman Case, Senators. I'm Jenny Staben, the Administrator of Industrial Siting for the Department of Environmental Quality. And as good housekeeping, whenever someone talks about my division, I just like to step up and
Fair enough.
make sure everything's correct and square.
Welcome.
Thank you, sir. The testimony you just heard is correct. When there is a permit application pending before the Industrial Siting Council, notice is provided to local governments that are expected to be impacted by that project. The description, scope, and size of a project, as it's described in an application, is literally what is permitted. If there are any changes to that, if any issues arise, so a change needs to occur, whether that's the construction or operation schedule, or a change in where a transmission line is or something like that, the permittee is expected, actually is required by the permit itself, to update the Industrial Siting Council and may be required to ask for a permit. Now, when those changes occur, as long as those changes were not required by the federal government, in every other case, the division does notify all permittees of the project. And when I say notify, those are certified return receipt letters to individuals. And we also publicly notice that a change is happening. So I just wanted to step up here today. Thank you for your time. and also just confirm information you've received.
Thank you very much. Any questions? Thank you. Good
Thank
job.
you.
Who else in the audience would like to testify to the committee? Who else in the audience? Is there anybody online? Okay, committee, I don't know if we can do justice to this bill. We've got about 10 minutes before we should head upstairs, but we could start on it and we could leave it open if that's all right and finish it up on Monday. But
I would move it.
we have a motion by Steinmetz, and so discussion on the bill. Senator Bonner.
Mr. Chairman, I'll get started here, I guess. On page 3, we're talking about the percentages and the minimum number of landowners. And so I'm just going to throw a number out there, see what happens. I move that page 3, line 10, we strike 80 and insert, or excuse me, 85 and insert 80. Similar action on line 15, strike 85, insert 80. And then on line 17, we're talking about the minimum number of landowners, strike 3 and insert 5.
Where's the 3 to 5? Oh, right,
Line
line 17.
17.
Got it right there.
Well, on 16
I'm
too, I
having trouble
guess.
with these bifocals today. Thank you very much.
And Mr. Chairman, I think the justification is that, I appreciate that, they tried to negotiate 13 years ago, but it seems like we're running up against some math problems there. And if we want to justify that this bill is allowing for, combination of one or, maybe one landowner, that's a problem, just not wanting to come to the table, and it actually has to add up. So that's nothing magic about those numbers. I figured it would lower the bar a little bit, but also make sure that we have at least a minimum number of landowners involved for that to be relevant, I guess. So that's the motion.
Mr. Chairman?
Thank you, Senator. Senator Steinmetz.
Could we bring the sponsor of the bill back up to help us work it? Is that
Sure,
something you do in this committee?
We always do that.
All right, come on, back up. And
Senator Crago.
Thank you, Mr. Chairman.
Comment on that?
I'm fine with that particular amendment. I think it makes sense. I agree the math does not work as it's currently written, and I can get into the history of why we ended up there, but I appreciate the good senator's motion.
And how about the 3 to 5? Is that a ditto?
That is a ditto. It's something that maybe we want to talk about, especially if we carry this bill over to Monday. I might try to come up with even a little bit better language on how that's written, but for now, I think that's a good step forward.
Okay, anybody else on the motion? Why don't you sit there? That'd be fine. You don't have to, but if you would.
No problem, Mr. Chairman. Happy to do so.
Great. It's very common that when we're working amendments, we'll seek more testimony. It's not like testimony's ever really hard closed. So it's just fair for everybody and better for the committee. So we have a motion on the table about line 10, 80%, and line 15, 80%, and line 17, 3 landowners to 5 landowners. Let's wait for Senator Lander to get situated, and we'll just get him up to speed. Oh, I saw you got called up by the governor's office. Everybody's wondering if there's a woodshed kind of experience.
Yeah, there's days you don't want to be called up there.
Senator Landon, we have an open motion on the table brought by Senator Bonner with respect to page 3, and it's the issue of the 85% in both cases. He's proposing to change that to 80%. And as part of his motion on line 17, where it has 3 landowners, he's proposing that we take that to 5. We've kind of had discussion. I think the sponsor thought it was okay. He may have further discussion on this issue if we carry this over to Monday, which I think is likely. And let's just give everybody a chance to breathe on this. But, so that's the motion on the table. Any further discussion? All those in favor signify by saying aye.
Aye.
Aye. And so any opposed? So that's carried. Anything else on the bill? Senator Land?
Chairman?
Yeah.
On page 6, I would move to.
How about a microphone there? Thanks.
Mr. Chairman, thank you. I would move on page 6 to strike the language on 10 through 12.
Yeah. Senator Lander, can you hold that for just a second? And let's
Yes.
conceptually talk about this.
Absolutely.
I'm wondering, I'm not necessarily opposed to that. I'm wondering if we couldn't strike Romanet I and Romanet 2, and what the implications of that are. I thought that Romanet 2 was just torturous. I don't even know what that's about. And I don't mean to tag on your motion. You can certainly stop me, but if we can have a general discussion. It's interesting to me, on line 14, it talks about kind of excluding the electric substations or interconnection facilities associated with existing or proposed transmission lines to serve load outside, to take load outside of Wyoming. But then on page 20, same page on line 21, we define energy collection system associated with commercial facilities generating electricity, and it means conductor infrastructure, including conductors, towers, substations, switchgear, and other components necessary to deliver power from any commercial facility generating electricity to, but not including electric substations or interconnection facilities. I think there's conflict in all that a little bit. So it's not clear to me.
So,
Senator
Mr.
Landon,
Chairman,
and
no,
then we'll go to the sponsor.
I appreciate, don't feel like you're tagging on, because I had a question on subparagraph II also. Romanet II. Connection system was suggested by the commissioner from Natrona County, because that language is troubled. I think it could probably be removed. I'm not sure why we, but
Wanna go to
maybe
the
the sponsor of the bill has some thoughts on that.
Senator Craigo.
Thank you, Mr. Chairman. So, and I think Mr. McGagney hit on that, and the language might not be quite right, but it was we were trying to get away from
Existing
having
facility.
having this applied to existing facilities or existing transmission lines or transmission lines in general, because there was some testimony that, for example, we could be talking on the border, for example, you have they're no longer collector lines, they become transmission lines from a project, and maybe it's right on the border going into one of our neighboring states, and we weren't trying to get to that issue. The language might not be right, but that's, I think, what it was intended to do on that particular issue. Obviously, the public utility language, that's an existing statute, and that was carried over from, I believe, the 815 section, 815D. That's why that's in there. So I think just a little bit of background, that wasn't something we came up with on our own. That was what's already in statute. And the definitions actually are from statute as well, which those are tortured. I mean, but that's what's in there. There is one word missing, I would note, on page 7, and I should have mentioned this when we were going through the bill. And it's actually an important word. It's on line.
Not a not, is it?
It's an up. It's the word up. On line 3, page 7, electricity up to. But that's in the definition already in the green books, but I think it missed our draft.
Yeah, it kind of changes that sentence.
So maybe we want to park this a little bit and think about it. So public utilities, they're kind of blessed with a public purpose. They get a certificate of public convenience and necessity. And that gives them sort of a statement that we find this in the public interest to have these things. Private facilities, and especially private facilities that don't even serve load in Wyoming, lose that public interest flavor, where the public interest comes about indirectly. Then you're talking about, what, do they have tax revenues? Do they facilitate the wind collection tax? But that's kind of a standard too to think about in this. And just what I'm going to propose is that we all come back together on Monday, bring our big brains, and we'll talk about these issues. Let's select a start time. Would people want to start earlier on Monday, or should we just start at 8 o'clock again? Would people be fine with earlier? Would 7:30 be okay? I don't want to push it too much. 7:30, I want to give notice to people out here. We'll start at 7:30 on Monday. We'll start working this bill. The moratorium bill would be behind it, and I'll stack more stuff behind that, and we'll do the best we can. If that's acceptable, we'll be adjourned till Monday. Thank you, everybody.
Lily, can we leave these here in our folders? That's a good idea, Mr. Chairman.
I just wanted to get started on it, so.
Can I ask you a real quick question on 183? Is that going to affect the data center, 1.3 million panels out south of town, the second one that's going to go in?
Since it's already going in, I'm